Good morning, everyone. This video presentation will be analyzing a negligence claim under Malaysian law and common law. The summary of the scenario given is that Sarah, customer of Freshmart, slipped on a spill in a store. Employees were aware of the hazard but failed to clean it or place warning signs. As a result, Sarah suffered injuries and financial loss. She has decided to sue Freshmart for negligence and seek for compensation. IRAC methodology will be used to analyze this case. The four key components of IRAC methodology are issue, rule, application, and conclusion. There are few issues needed to be determined. Firstly, does Freshmart owe Sarah duty of care? Second, has Freshmart breached that duty of care? Has the breach of duty caused Sarah physical or mental harm or economic loss? In addition, we also need to determine that were there any defenses could Freshmart raise in response to Sarah's negligence claim. So English case Donahue versus Davidson AC 562 established the neighbor principle, which states that you must take reasonable care to avoid actions that could foreseeably harm others who are so closely affected by your conduct. The House of Lords introduced the threefold test as a result of the English case of Carpero Industry plc versus Dickman, UKHL 2. This test requires a reasonable foresight of harm, sufficient proximity of relationship, and a fair, just, and reasonable to impose a duty in order for duty of care to arise in negligence. So moving on to the next. Breach of duty occurs when the defendant fails to meet the standard of care expected of a reasonable person. Now, the case of Barnett versus Chelsea and Kensington Hospital Management Committee 1QB428 is a case that introduced a but-for test. If the plaintiff can show that but for the negligence, the injury would not have occurred, then the negligence is seen to have caused the injury. There are actually two types of defenses. Contributory negligence under Section 12(1) of the Civil Law Act 1956 states that if a person suffers damage due to both their own fault and another's fault, their claim for damages will be reduced accordingly. Voluntary non-fit injury, which also known as a voluntary assumption of risk, is a way to avoid liability by proving that the plaintiff accepted the risk of doing something voluntarily. Now, application. First of all, a threefold test can be applied. Now let's look back to the threefold test. There was a reasonable foresight of harm suffered by Sarah. There was also sufficient proximity of relationship between Sarah and Freshmart. Lastly, it is fair, just, and reasonable to impose a duty to the Freshmart. So since all the elements were fulfilled, Freshmart owed Sarah a duty of care. Apparently, Freshmart fails to meet the standard of care expected of a store. Freshmart's employees were aware of the spill but failed to clean the spill or place a warning sign around the spill is considered as a breach. So, but for the spill not being cleaned up or a warning sign not being placed, Sarah would not have slipped herself and injured herself. Therefore, Freshmart is liable for negligence as the breach of duty directly led to Sarah's physical and financial loss. For contributory negligence, Freshmart may argue that Sarah was partially at fault for not noticing the spill. However, this is unlikely to success unless the spill was marked clearly. Other than that, voluntary non-fit injury will not apply as well unless Freshmart can prove that Sarah accepted the risk of walking on a dangerous surface, which is improbable. There are a few policy considerations in this case. For example, enhance customer safety. Businesses should prioritize customer safety to avoid reputational harm. Besides, legal compliance. Business may need to develop stronger safety rules and maintain compliance with legal obligations of care. Moreover, employee training. This can help to identify and resolve dangers efficiently. Last but not least, customer trust. A strong emphasis on safety can help build client trust and loyalty. In conclusion, Sarah has a strong claim for negligence against Freshmart in both Malaysian law and common law. Freshmart owed her a duty of care, which they breached by failing to address a known hazard. The breach directly led to her injuries, and defenses are unlikely to succeed. Therefore, Sarah should be entitled to a compensation for her injuries, medical expenses, and loss of wages. So that's all for me. Thank you.